Okay, I thought I'd start off by just sort of giving a bit of context here by looking at some statistics for the European Commission, DG Comp. And if we start off by looking at this, is this going to work? Oh no, there we go. Looking at the purple line, what I've got here is remedies and prohibitions over decisions. So this is sort of the propensity to do something, intervene, to require some sort of intervention. I go from 1991 up to 2013. 2013 is based on the first 5 months. So let's start with the purple line, which is the this one here, and we're looking between sort of 5 and 12% as a percentage as the sort of remedy percentages. Then around the turn of the century, things seem to stabilize at about, I think, sort of 6 or 7%, and not much change there. Okay, so there's a sort of settling in and perhaps a learning there. I'll come back to learning later. The second thing is the green, which is the share of prohibitions in these sort of remedies plus prohibitions. And here you'll notice quite a lot more fluctuation. To begin with, not much, then the odd peak year, quite fluctuating around. And then something happened around here, and that's why I've got this line here, 2002. It was, of course, the year in which the merger task force lost 3 big cases, Airtours, Schneider, and Tetra Laval. And you'll see it had a bit of an impact on prohibitions. These represent just one prohibition in each year there, so 2 prohibitions between 2002 and 2010. And then we have, after this line here, which I've drawn this for not any particular event, except Ph.I became chief competition economist, as was already noticed in the front row. So I was going to call this the Ph.I effect, that we suddenly get these prohibitions. Now that's not an arrow. It's not meant to be. That's a Microsoft triangle, but it just looks like it's heading off up there. But that's not meant to be it. And that's based simply on 5 months. And there were 2 prohibitions, one January and February this year. I'll mention those a little bit later. But it does seem that the reverses in court and the reforms moved away from prohibitions and once more back towards any actions are taken are in the forms of remedies, so undertakings in lieu to allow the merger to go ahead. And maybe confidence or Ph.I have changed things back to where they were before. Okay, so my role in this, when we had this sort of carved up, as Tom said, was to look at, well, what do we learn from economics in relation to remedies? So I think the first thing that we learn is whatever theory of harm that we're looking at, we should then use that to test the remedy. So if you're using, if you were using market shares, then you'd expect to do it straight on market shares. If you're using UPP, you want to check the remedy with that. If you're using any of these other simulations, then you would want to use that method. So you can check your remedies against whatever you've used in terms of the theory of harm. Now, when it comes to it in differentiated product markets, we talk about remedies and talk about prohibitions and avoiding prohibitions. In differentiated product markets, they are essentially, the remedy is prohibition within the market, whatever bit of the market, and across Europe, very often, the geographic market is national, so you have 20-odd different geographic markets and lots of products. So the prohibition often takes place, or used to take place in particular, within just whatever bit of the market was, or bit of market was affected. Less used are other models of simulation which you can use. I mean, in our book, my book with Steve Davis, looking at some older cases, we found it very useful to use a simple Corno model with capacity and something which is, I suppose, something between UPP, IPR for those, and that sort of technique has also been used by the OFT since. The first lesson to learn from going beyond that, of using the original theory of harm to try and understand the consequences of the remedy, is that you shouldn't create another harm in achieving the remedy. And the most famous case here is Comte-Genie and Ray's analysis of Nestlé Perrier. So Nestlé Perrier was a merger of 30% plus 20%. The next biggest firm was BSN with 25%. For some reason, unilateral effects were not thought the most relevant. Looking at coordinated effects, the original merger then, if you were only looking at coordinated effects, would have left a considerable asymmetry and therefore an incentive for BSN to break out from the coordinated effects. The remedy involves selling some major brands from the merged entity to BSN to bring them much more equal and therefore much more likely to be able to coordinate their behavior. So not only use your original theory of harm, but also to check that against creating any alternative theory of harm. Conceptually, you may have other assets which might lead to other effects. Some people have claimed that, notably as a paper by Nicolas Petit recently, that it's particularly important to consider remedies in the context of coordinated effects. And that is because other aspects of competition policy are so difficult to use against any sort of coordinated effects if you let a merger through which creates coordinated effects. And I think there's some truth in that. There's a particular caution. You certainly find it incredibly difficult to use the other aspects of competition policy to address a coordinated effects issue once it's in the market. But also, I think there are very serious problems with using Article 102 or whatever to try and tackle unilateral effects mergers which have been allowed through, especially if they're in small markets. There are wider aspects of competition policy. I think that the lessons from the previous slide are really important, very clear understanding of where we are on that. There are other bits of economic theory around, and many of which are sort of still developing, and I don't think they're strong enough yet for actually use very much in practical policy, but I'm going to mention them. So the consideration of entry, and it's quite possible that entry can be deterred. If you sell off assets to a potential entrant, then that potential entrant may not come in as competitive a way as they would have done otherwise in the absence of the divestiture which they can buy. There are other issues to do with creation of efficiency and the dynamics of mergers. What one merger might lead to another, and that's very much a new research area. But the third point on deterrence effects picks up from some of the discussion before lunch, and indeed Tommaso Duso mentioned one of his papers with one of his many sets of friends and co-authors. And they find that if you look at the recent history of phase 1 remedies, then they tend to deter anti-competitive mergers using the somewhat controversial event study type approach. Before 2004, it was only prohibitions that seemed to matter, I think, in an earlier version of the work. But as I say, I think these sorts of ideas are important ones that will be developed over the coming years, and I think we have more to learn in this area. In terms of remedy implementation, then there was, I mean, the early years of Remedies they were really quite crudely and badly implemented. We've heard a little bit about this yesterday. There were big studies on the failure of merger remedies, first by the DOJ and FTC in the around about 1997, I think, and then there was a study for Europe in the around about 2004, I think. And there were a lot of lessons learned. And some of those could have been expected from the economics. And there are clearly, when you're talking about antitrust product markets, there are important economies of scope. And you can't just sell a product in one, very often you can't in just one antitrust market. Where the markets are carved up by geography and by product line and things. You need a whole package of those products defined on antitrust market product and geographic definitions. And this was indeed a major cause of failure of merger divestitures in the early days. And I think some of the lessons have been learned. If you look at these are the four most recent prohibitions. Certainly the UPS TNT is a very clear example of this. I think it was actually mentioned earlier. This is a parcels merger. What the remedies offered by the parties were in 17 countries to divest their sort of parcels business, but you still needed a full network of all the countries in order to have an effective parcel delivery service. And it's thought that even though this would have eliminated all the overlap, it wouldn't have created a viable business. The other ones you can, the Deutsche Börse case, there's a thought that the overlap of, I think it's single stock derivatives was the offered remedy for that, but that wouldn't have been a viable standalone business. Okay. The middle one here is a point that Joe Farrell made 10 years ago, but I think there's still hasn't been properly learned, is that in any divestiture, there is going to be collusion between the buyer and the seller of a business. So if you sell the business, the buyer will be willing to pay a certain price. For a profitable business, they'll pay a higher price than for an unprofitable business. But if you can sell a degraded asset, you may get a lower price for it, but you can sell it, and they will be a less effective competitor, and so you will get, going forwards, greater market power and market rents. And this is a very simple but a very powerful insight that the process of divestiture, restoring market structure, does not restore competition. And I think that's the strapline to much of the research on merger remedies. There are also big transaction costs when you're carving out businesses, opportunistic withholding of information, and monitoring of behavioral remedies. I've been given less than 4 minutes from here. I was going to say a bit about, let me tell you, the need for, and this is a consultation that's going on at the moment about whether there you should be able to have behavioral remedies against, not behavioral remedies, you should have remedies against minority shareholdings. This was again mentioned yesterday. I think it's a very important gap at the European level. Quick illustration, Ryanair taking over Aer Lingus, or trying to take over Aer Lingus. It was prohibited about, I don't know, 6 or 7 years ago now perhaps. They had built up a stake of 25%. After the prohibition, they bought another 5%. They're sitting on 30%. What they do, they stopped a special resolution on raising capital. They demanded talks with the management of Aer Lingus. They brought up 2 extraordinary general meetings to try and change corporate strategy. They did not have a decisive control of Aer Lingus, so it was out of reach of the Commission. Of course, just very recently, the UK Competition Commission has looked at this, and their provisional finding is, yeah, they do need to sell down their stake. So I think that they just shouldn't have got there, dragged on this long. Ryanair can't buy anywhere other airline, it can't build up scale, it can't get wherever it wants. Okay, I just want to say something about early settlement. Why is early settlement? I'm talking about whether you can settle in phase 1 or as opposed to phase 2. Well, phase 2 is very costly for the firms and for the agencies, and it also delays benefits to consumers if this is going to be a valuable merger. But on the other hand, you have longer time to understand the merger and to come to a more accurate decision and also negotiate remedies. There may also be strategic behaviour in offering remedies. It may be that a firm is desperate to get this through, so will offer remedies which sacrifice long-term efficiencies, or it may be that it tries to bluff through. So I think it's important to try and understand it. This is what happens with this first line is a technical change where phase 1 remedies were not necessarily legal in the early days of the merger regulation. So ignore that. And we can see here that there's essentially a gradual increase in the proportion of mergers which are agreed in phase 1. You can think of this as learning that both the firms or their advisors are learning how to, or the needs of the Commission, or the Commission's getting more consistent. But there has been, if we look at the Phi effect, a reversion down to where we were over here. And these are small numbers of observations, but I put them forward to provoke discussion, not just to provoke Phi. Right, okay. Just want to say, well, what does determine early settlement? Well, I've got a whole bunch of stuff here which is basically to do with the opportunity cost of delay. If there are a lot of markets there that the firm wants to get through and integrate, then it's more impatient. If the market is complex to analyze because of the range of theories of harm or something, then that causes delay. But it's quite interesting, look, the actual caseload. If the caseload in DG Comp is either very low or very high, then there is a greater chance of early settlement. Now, the way I read this is that if there's a very low caseload, you can put lots of resources in, you can understand it. Greater pressure of caseload that leads you to sort of not being worried, pushing it through to phase 2. Very high caseload, panic. Let's settle quickly, we can't go through to phase 2. And I think those are the cases where you're likely to get maybe inadequate remedies going through. Right. I'm required to stop here.
Comes at the end. Thank you, Bruce. Thanks a lot.